There's a knock at your front door. You open it. Standing there is an ATF agent with a clipboard and a badge, and he says the words that should make every American's blood run cold. "We have records showing you purchased multiple firearms. We need to confirm you still possess these weapons. We need to see your guns. Now." Or maybe you're driving home from the range, you get pulled over for a minor traffic violation, and the cop walks up to your window and demands, "Hand over any weapons in this vehicle. I need to inspect them for officer safety." In both scenarios, the question is the same, and it's a question that strikes at the heart of whether we live in a free country or a police state. Can you refuse when cops demand to see your guns? Because what's happening right now across America is a systematic campaign to normalize warrantless inspections of legally owned firearms. And if you don't know your rights, if you don't know exactly what to say and what not to say, when government agents show up demanding access to your property, you're going to end up surrendering constitutional protections that generations of Americans fought and died to preserve. So can you refuse? The answer is yes, but with critical exceptions, and understanding those exceptions could be the difference between protecting your rights and watching an ATF agent walk through your home without a warrant because you didn't know you could say no. And if you're someone who believes the Constitution still means something, if you think Americans deserve to know when government authority crosses the line into tyranny, subscribe to this channel right now because we're exposing exactly what federal agents and police don't want you understanding about your rights. Hit that button, turn on notifications, and drop a comment telling me if you've ever had ATF or police show up demanding to see your firearms and what happened. Let's document how often this actually occurs and where it's happening most. Now let's break down the two most common scenarios where cops demand to see your guns and exactly what you're legally required to do versus what they want you to think you're required to do. First scenario. ATF agents or local police show up at your home. They knock on your door. You answer, and they tell you they have records showing you purchased 2 or more firearms within a certain time frame, and they need to confirm you still own those weapons so they can keep track of them. This is happening. This isn't theoretical. There are documented cases of ATF agents conducting exactly these kinds of home visits, showing up at law-abiding citizens' houses demanding to inspect firearms that were legally purchased, legally owned, and legally stored. And the way they frame it makes it sound like you have no choice, like this is just routine procedure, like you're required to comply. But here's what they're not telling you. You are under absolutely no legal obligation to show them anything, to answer any questions, or to even open your door. None. Zero. The Fourth Amendment protects you from unreasonable searches and seizures, and that protection doesn't evaporate just because you exercised your Second Amendment right to purchase firearms. Now let's get specific because there's an important distinction between different types of firearms under federal law. The National Firearms Act regulates certain weapons differently than conventional firearms. NFA weapons include short-barreled rifles, short-barreled shotguns, suppressors, machine guns, and other destructive devices as defined in federal code. These are treated differently from conventional firearms like handguns, standard rifles, and AR-15s. When you purchase an NFA weapon, you fill out ATF Form 1 or Form 4, you pay a tax stamp, you go through an extensive background check and registration process. And here's where a lot of gun owners get confused. Many people believe that because they registered an NFA weapon, because they went through that federal approval process, they somehow waived their Fourth Amendment rights, and the ATF can now show up whenever they want to inspect those weapons. That is absolutely, categorically false. Nowhere on those ATF forms, not on Form 1, not on Form 4, nowhere in the entire registration process did you sign a waiver of your constitutional protection against unreasonable searches. You did not consent to warrantless home inspections. You did not surrender your Fourth Amendment rights just because you legally purchased a suppressor or a short-barreled rifle. The ATF wants you to think otherwise. They show up at your door, they reference the fact that you own NFA items, they make it sound official and mandatory, and they're counting on you not knowing that they cannot enter your home without a warrant. Whether you own machine guns or handguns, whether your firearms are NFA regulated or conventional, your constitutional protections remain intact. And yet, ATF agents are conducting what they call knock and talks. They knock on your door, they try to talk their way inside, they act like they have authority they don't actually possess, and they're hoping you'll voluntarily surrender your rights because you don't know any better. This is a deliberate strategy. It's not a mistake. It's not agents being overzealous. It's a calculated effort to normalize warrantless inspections by making them seem routine and required when they're neither. So what should you do if ATF or police show up at your home demanding to see your firearms? First, and most important, you do not have to answer the door. You are under no legal obligation to open your door, to speak with agents through the door, to engage with them in any way. Your constitutional rights to remain silent and to be secure in your home apply fully. The only circumstances under which law enforcement can legally enter your home are these four. First, if you give them consent, which you should never do. Second, if they have a valid search warrant supported by a sworn affidavit establishing probable cause to search your property. Third, if they have a valid arrest warrant for someone inside the home. Fourth, if exigent circumstances exist, meaning there's an emergency situation such as someone destroying evidence, someone in immediate danger, or a crime actively being committed. Those are the only four scenarios. We want to check if you still own those guns, doesn't qualify under any of them. And here's how you know they don't actually have legal authority. If they had a search warrant or an arrest warrant, they wouldn't be knocking politely and asking your permission. They'd be coming through the door whether you liked it or not. The fact that they're standing there making requests instead of demands tells you everything you need to know. They're hoping you'll voluntarily waive your rights. Now, if you do open that door, if you do start talking with them, understand what's actually happening. They are investigating you. They're not there for a friendly chat. While they're talking to you, they're looking past you into your home. They're watching for anything in plain view that could give them probable cause to enter and search. The plain view doctrine says that if police can see contraband or evidence of a crime from a lawful vantage point, like your open doorway, they can seize that evidence without a warrant. So by opening the door and engaging with them, you're giving them the opportunity to manufacture probable cause based on anything they claim to have seen in your home. This is why you have everything to lose and nothing to gain by talking to them. Don't open the door unless the officer explicitly states they have a valid search warrant. Even then, you can request they slide the warrant under the door so you can review it before opening. They are legally required to present the warrant before you have to grant them entry. If they do have a valid search warrant or arrest warrant, then yes, you must open the door, but you still don't have to engage in conversation. You can say, "Officer, I exercise my right to remain silent," and then you stay silent. The only other thing you should say is, "I do not consent to any search of any item, person, place, or thing that is not expressly authorized in this search warrant." Why? Because there are documented cases of agents using search warrants to go beyond their legal scope, and you need to clearly establish on record that you are not consenting to anything beyond what the warrant specifically allows. If you're serious about protecting your rights, if you want information that actually helps you instead of just making you feel informed while agents violate your constitutional protections, subscribe right now. Hit that button, leave a comment with your experiences, and share this with every gun owner you know who needs to understand that compliance is not always required and silence is often your best defense. Now let's move to the second scenario because this is where most gun owners actually encounter these demands. You're driving. Cop pulls you over. Maybe you were speeding. Maybe you failed to signal a lane change. Maybe your taillight is out. Standard traffic stop. The officer approaches your window and says, "I need to see any weapons you have in this vehicle. Hand over those guns." Can he legally demand this? Can he search your car without your consent? And what should you actually say in this situation? First, let's establish some basic protocols that apply to every traffic stop, whether you're armed or not. When you get pulled over, You keep your hands on the steering wheel at all times. You remain calm, polite, and collected. You provide what's legally required in your state, typically driver's license, proof of insurance, and sometimes registration, though most cops can run registration from their vehicle. You keep your mouth shut beyond basic courteous acknowledgement. Don't make quick movements. Don't reach under your seat. Don't grab for anything on the passenger side. Why? Because cops will characterize any sudden movement as furtive movements, and they'll use that characterization to justify officer safety concerns, which then justifies getting you out of the car, searching you, and potentially searching your vehicle. If the officer writes you a ticket, you take it without arguing, even if you think you're innocent. Arguing on the side of the road does absolutely nothing except give the officer ammunition to write in his report that you were aggressive, combative, and uncooperative. Language that gets used to justify escalation and extended detention. You can fight the ticket in court. You cannot fight it effectively with an armed officer on the side of a highway. Now, when that officer walks up and starts asking questions, and they always ask questions, you need to understand what's actually happening. When he says, "Do you know why I stopped you?" Or, "You were going pretty fast back there, weren't you?" He's not looking for honest conversation. He's fishing for admissions of guilt. He's doing an attitude check. He's figuring out if you're going to be easy to manipulate or if you're going to assert your rights. You have an absolute constitutional right to remain silent during a traffic stop. You can exercise that right by saying, "Officer, I'm exercising my right to remain silent." He might act confused. He might accuse you of being difficult or playing games. Do not engage. Do not argue. You've invoked your right clearly, and now you stay quiet. Either the officer has enough evidence to write you a ticket or he doesn't. Anything you say can only hurt you. It will never help you talk your way out of a citation or search. Now, here's where it gets critical for gun owners. You always have the right to refuse a police search of your vehicle. Always. This is your Fourth Amendment protection, and it doesn't disappear just because you got pulled over. But many gun owners don't know this, or they know it theoretically, but cave the moment a cop asks because they think refusing makes them look guilty. Pennsylvania v. Mims established that police can order you to exit your vehicle during a traffic stop if they can articulate facts establishing they were in fear for officer safety. In practice, cops can almost always cobble together some justification for getting you out of the car. Your demeanor, your tone, your nervousness, whatever. So if the officer orders you out, you comply. You get out slowly, you keep your hands visible, and you do not resist. But getting out of the car is not the same as consenting to a search. When you exit the vehicle, you immediately invoke your right to remain silent if you haven't already. If the officer has legal justification, which you'll only know later in court, he can pat you down for weapons. If he does this, you let him. Do not physically resist, because if you do, you're getting arrested for resisting arrest, assault on a public servant, disorderly conduct, and whatever else they can pile on. Instead, you verbalize clearly. "Officer, I do not consent to this search, but I am not resisting arrest." You're making it clear on any recording that you're not giving consent while also not physically resisting, which gives your attorney the best chance to challenge the search in court later. Now comes the vehicle search request. After the officer searches your person and finds nothing, he's probably going to say something like, "You don't mind if I search your car, do you?" It'll be phrased in a way that sounds less like a question and more like a statement, as if your consent is assumed. If you stay silent, courts have actually ruled in some cases that a reasonable person would have objected, so your silence gets interpreted as implied consent. You need to state clearly and unambiguously, "Officer, I do not consent to a search of my vehicle." Then you stop talking. Because here's what happens next. The officer will immediately start playing psychological games. He'll say things like, "I thought everything was going well here. I'm just trying to get you on your way. What are you hiding? Why wouldn't you consent if you had nothing to hide?" This is manipulation. He's trying to make you feel like exercising your constitutional rights makes you look guilty, and that an innocent person would just let him tear through your entire vehicle for an hour looking for anything he can charge you with. And make no mistake, If you consent to a vehicle search, you are giving that officer carte blanche authority to keep you on the side of the road for as long as it takes to conduct a thorough search. I've seen searches where they remove seats, tear through every compartment, spread your belongings across the pavement, and spend an hour or more going through everything. Items get broken, items get lost, your property gets destroyed, and all of it is legal because you consented. When you consent to a search, you waive virtually all Fourth Amendment protections. Even if the officer goes beyond the scope of what you thought you were consenting to, courts will often allow the evidence anyway because consent is treated as curing constitutional violations. So the solution is simple: never consent. Exercise your constitutional right to refuse, and refusing consent cannot be used against you in court. It's not evidence of guilt. It's the exercise of a fundamental right that the Fourth Amendment explicitly protects. But what if the stop keeps extending? What if the officer keeps holding you there, keeps asking questions, keeps trying to find reasons to search? At some point, you need to establish whether you're being detained or if you're free to go. Under Rodriguez v. United States, police cannot extend a traffic stop beyond the time reasonably necessary to handle the matter for which you were pulled over. If you got stopped for speeding, they can't hold you for an hour while they wait for a drug dog or keep fishing for consent to search. They're supposed to write the ticket and let you go, but they'll extend the stop as long as you sit there passively because they'll claim it was a consensual encounter and you were voluntarily staying to talk. So you ask, "Officer, am I free to leave?" If he says yes, you leave immediately. If he says no, you've established that you're being detained against your will, and you state again, "I do not consent to a search of my vehicle, and I exercise my right to remain silent." You'll need to repeat this. You'll need to keep asking if you're free to go. Why? Because you're equipping your attorney with ammunition to argue in court that the stop was illegally extended beyond its lawful scope, which could get any evidence suppressed. Now back to the original question: can an officer demand to see your guns during a traffic stop? The answer is no, not without probable cause to search your vehicle. Simply pulling you over for a traffic violation does not give police authority to search your car or demand to see firearms they have no reason to believe exist. The most common way officers claim they have probable cause is through officer safety concerns, which they establish by claiming you made furtive movements or acted in a way that objectively placed them in fear. This is why your behavior during the stop matters so much. If you keep your hands visible, move slowly, stay calm, and don't give them anything to misinterpret as threatening, it becomes much harder for them to justify a search based on officer safety. If you follow the protocols we've discussed, many courts would rule that the officer lacked objective justification for a search. But if you're jerking around, reaching under seats, making sudden movements, you're handing them the legal basis they need to tear through your vehicle. And here's the final piece that every gun owner needs burned into their memory. If the officer tells you that you're not free to go, if he's continuing to hold you in what's clearly become a detention rather than a consensual encounter, you need to invoke not just your Fifth Amendment right to remain silent, but also your Sixth Amendment right to counsel. You say, "I exercise my right to remain silent. I exercise my Sixth Amendment right to counsel, and I want to speak with a lawyer." This makes it crystal clear that there will be no further interrogation, no further conversation, and that you're standing behind all of your constitutional protections. Don't wait for them to read you Miranda rights because they often won't. If they're not questioning you, they're not required to Mirandize you, so the only way to protect yourself is to invoke these rights yourself explicitly and immediately. People always ask me, should I wait until they arrest me and read my Miranda rights before asking for a lawyer? No, by then it's too late. By then you've potentially said things that can be used against you. You invoke your rights as soon as it's clear the encounter is moving from a simple traffic stop into an investigation or detention, and you don't argue about it. You don't explain why you're invoking them. You don't try to convince the officer you're one of the good guys. You state your rights clearly, and then you shut up completely. Let your attorney do the talking later in a courtroom where your words actually matter and where you're protected, not on the side of the road where anything you say only helps the prosecution build a case against you. So let's bring this home with the bottom line that every American gun owner needs to understand in 2026. Can cops demand to see your guns at your home? No, absolutely not. They cannot enter your property without a search warrant, arrest warrant, exigent circumstances, or your consent. Do not give consent. Do not open the door unless they announce they have a warrant. Even then, make them slide it under the door so you can review it before granting entry. And if they do enter with a warrant, invoke your right to remain silent and state clearly that you do not consent to any search beyond what's specified in the warrant. Can cops demand to see your guns during a traffic stop? No, not without probable cause to search your vehicle. You have every right to refuse consent to a search. You have every right to remain silent. You have every right to ask if you're free to go. And exercising these rights does not make you look guilty. It makes you look like someone who understands that the Constitution is supposed to protect citizens from government overreach, not serve as a suggestion that gets ignored whenever it's inconvenient for law enforcement. What we're watching in 2026 is the systematic normalization of warrantless searches and inspections of legally owned firearms. ATF agents showing up at homes demanding to confirm weapon ownership. Police using traffic stops as pretexts to search vehicles and inspect guns they have no legal basis to examine. And it's working because most gun owners don't know they can say no. They think cooperation is required. They think refusing consent makes them look suspicious. They think arguing about constitutional rights on the side of the road will somehow protect them, when in reality, it just escalates the situation. So the system continues grinding forward, eroding the Fourth Amendment piece by piece, traffic stop by traffic stop, knock and talk by knock and talk, until we reach a point where Americans no longer even question whether government agents have the right to inspect their property without warrants because it's become so routine that nobody remembers it was ever supposed to be different. But here's what gives me hope. You're watching this video. You're educating yourself. You're learning that compliance isn't always required, and that constitutional rights still mean something if you're willing to assert them clearly and stand behind them even when it's uncomfortable. So subscribe to this channel if you haven't already. Hit that button right now, turn on notifications, and commit to being someone who actually knows their rights instead of someone who finds out they had rights only after they've been violated. Leave a comment telling me your state and your experiences with police or ATF demanding to see your firearms. Share this video with every gun owner you know because this information is worthless if it stays with you. It needs to spread to every American who owns firearms and thinks the Second Amendment protects their right to bear arms while somehow not understanding that the Fourth Amendment protects their right to not have those arms inspected without warrants whenever government agents feel like showing up. The fight for your rights doesn't happen in Congress or in courtrooms alone. It happens every single day when you refuse to open the door for warrantless searches. It happens when you clearly state, "I do not consent," during a traffic stop. It happens when you invoke your right to remain silent and your right to counsel instead of trying to talk your way out of situations that only get worse the more you talk. It happens when you understand that police and federal agents are not your friends during these encounters. They are investigators looking for probable cause to search, seize, and arrest, and everything you say or do either helps them or helps you, never both. So choose to help yourself, assert your rights, document encounters, know the law, and refuse to accept that just because you legally own firearms, you've somehow surrendered your constitutional protections against unreasonable government intrusion into your home and property. Because if we accept that trade, if we agree that gun ownership means government agents can inspect our weapons whenever they want, then the Second Amendment becomes meaningless because it's protected by a Fourth Amendment that no longer exists.